Order, order. Welcome to today's meeting of the Joint Committee on the National Security Strategies. This is the first evidence session into our inquiry into espionage cases and the Official Secrets Act following the collapse of the case involving the alleged spying activity for China. Our objective from these sessions is to bring clarity to questions that have arisen in recent weeks, to ensure proper accountability and review the adequacy of processes and decision-making. It's unusual for us to examine the details of such a case, but it is warranted given the scale of public concern. So we're going to be hearing from officials today and ministers on Wednesday morning. I'd like to remind witnesses of their obligations to Parliament and the expectation of providing as complete answers as possible. So perhaps I could start by inviting those present just to introduce themselves.
Thank you, Chair. My name is Stephen Parkinson. I'm the Director of Public Prosecutions.
I'm Tom Little, KC, First Senior Treasury Counsel, and was the instructed advocate in the case that's the primary issue of your concern.
Thank you. Stephen Parkinson, the situation we find ourselves in is quite extraordinary. Who do you think is responsible for the collapse of this case?
First of all, Chair, may I say how disappointed I am that this case could not proceed to trial. I recognise and absolutely endorse the points that you have made about the nature of this case and in particular the level of public concern. And I'm very conscious indeed that there were two victims in this case who were members of the House of Commons, who were the victims of a gross breach of trust, as was Parliament itself. In terms of your question, if I may say so, I don't think it is a question of blame. The responsibility of prosecutors is to place cases before the court on the basis of sufficient evidence to secure a conviction. And ultimately, the issue in this case is that we were not able to provide the evidence to sustain the case in respect of one essential element, which was the element that China was an enemy, as was required by the statute.
Do you think on that point, do you think there was or did you ever get the feeling that the government wanted this case to fail?
Nothing reached me. I should, I'm sure it's known to many members of the committee, but if I may just explain the division of responsibilities in terms of criminal cases. So we don't investigate cases. We look at the evidence and we make decisions about whether it meets our tests. But the relevance of this to your question is that until a very late stage, we weren't engaged directly with any witness. That was the responsibility of the police. So I do not know anything about the background to the statements that were produced. Our responsibility was to look at the evidence, to ask investigators to obtain more evidence, if that was possible, and then evaluate whether our tests were met. And the key test for prosecutors is the evidential test, which is there a realistic prospect of securing a conviction?
So you felt that you didn't have the evidence that was robust to put before a jury?
We did in the first instance.
What changed?
What changed was the ruling in a case called reshape, which imposed an additional requirement. So, as I've explained, one of the elements of the offence was to establish that China was an enemy, and our route to doing that was to frame a case on the basis that China was a threat to national security.
Threat or an active threat?
Well, at the time, a threat. The difference that Rusev, which was another case based on the same prosecution theory, in fact, of threat to national security, there was a ruling in that case which said that you can mount a case on the basis that, in that instance, Russia is a threat to national security, but you have to show that at the material time it was an active or a current threat to national security. So the statement that we had at the time in our case didn't go that far, so we asked for confirmation that at the material time, which was the dates of the offence, China was an active threat to national security. That we did not think that this would be a difficulty, but in the end, it proved to be a sticking point, and we were unable to secure that evidence.
When you decided to drop the case, what advice did you take before coming to that decision?
Well, there was an enormously experienced team involved in this case, comprising internal lawyers, very experienced in national security cases. Mr. Little, who sits on my right, was involved at the outset and was trial counsel. So we had advice from Mr. Little, we had internal discussions, and then the way these things develop with complex and sensitive cases in the Crown Prosecution Service, senior people have to be consulted. That happened as well. And a decision was taken, which ultimately I endorsed, that we would not be able to meet our test, that there was a realistic prospect of a conviction.
And at what point did you decide that there was no alternative charges that could be pressed? Given the challenges that we'll come on to in a moment, but at what point do you decide there was no alternative charges that you might level at these two, such as plotting to or planning to commit espionage or any other similar legislation?
Well, all this was in the mix, really, at a point at which we concluded that we could not prosecute the case, and that was late August of this year. If I may, perhaps I could just bring in Mr. Little at this point, who was closely involved in advising us on the issue.
So just dealing with a couple of matters that you've raised, perhaps to try and join up some of the dots. The critical meeting, which was an unusual situation for leading counsel for the Crown to meet a witness in these circumstances, and I did that on the 14th of August, and I have a very clear recollection of that meeting because I needed to understand why the two previous attempts to get statements, statement number 2 and statement number 3 from Mr. Collins, why, as it were, what I thought would be relatively straightforward to be said, which was there was an active or current threat to national security, why that hadn't been articulated in clear terms. I also want to make it clear I was not concerned if the witness didn't use the word enemy. That would be a matter for the jury, but I needed to have the evidence to support the submission to the jury, and the witness was clear to me that he would not say that China posed an active threat to national security at the material time. That was in answer to what I regard as the million-dollar question in the case, and once he had said that, the current prosecution for those charges was effectively unsustainable. That's my carefully reflected position. I didn't jump to that immediately. I advised on the 22nd of August, having reflected over it as far as those charges were concerned. There was other discussion then about alternative charges, but I don't think anyone should misunderstand the effect of what the witness had said. That would have been disclosable, and it brought this case effectively to a crashing halt as far as that was concerned with that witness, who is the Deputy National Security Advisor to the Cabinet. It's very different to the position of giving away a witness who witnesses a criminal incident on the street for reasons that I hope are obvious. But we did give very careful consideration as to whether this was remediable. And I concluded, but more importantly we concluded, that is the entire prosecution team, that it was not.
Okay. I want to bring in Dame Emily, but just briefly, if I could, Lord Hutton.
Yes, a question really for the Director of Public Prosecutions. You said in your opening statement to us, sir, that you were disappointed that
Yes.
this prosecution couldn't be brought. And it sounds like you think that there was enough evidence, clearly, to merit a prosecution and a reasonable chance of conviction. And your argument is purely that the Rousseff case changed that.
Essentially, yes. I mean, I was disappointed. We felt that we had a good enough case to prosecute. We'd obviously spent an enormous amount of effort getting the case to the point that we did. And we felt that there should be no difficulty, in fact, in answering the question that we posed. Was China an active threat to national security at the material time? We thought that would be evidence that could be given relatively easily, but it turned out to be a sticking point. We first asked that question, so the ruling in Rousseff came out on the 31st of May 2024. We asked that question on the 11th of June. We slightly amended it the following day. It took 14 months to get the answer to that question, and the answer was no. And it took quite a lot of effort on our part to try and get the answer. But what you can't do as a prosecutor is tell people what to say. You can only obviously ask questions. But we did put a lot of effort into it, and yes, we did feel disappointed and frustrated. This was an important case.
Did it ever sort of occur to either of you that, given that if this case had gone to a trial, a jury would have had to have decided what the threat to national security was? And many people, certainly in this place, would think you can't have national security without economic security. And the Deputy National Security Advisor was very clear of the active threat to our economic security that China posed. And neither of you felt that that was sufficient basis to put an argument to the jury that that in itself could have constituted a threat to our wider security interests.
The question that was posed was, at the material time, was China an active threat to national security? The answer we got with the second statement was it was a threat to economic security. So the question wasn't answered in terms. But if I can just really reiterate what Mr. Little has said, the issue wasn't so much the statements that we were given, it was what was missing. And the key question which would have been posed in cross-examination was the question that we posed in June. Was China an active threat to national security at the material time? And the answer was that confirmation couldn't have been given. Now, can I just explain the impact of that? So the way criminal procedure works, the prosecution lays out its evidence before the court, and at the close of the prosecution case, the defence are entitled to make a submission of no case to answer. And they can do that if any element of the offence is not satisfied. And if the judge concludes that no reasonable jury properly directed could reach that conclusion, then he will stop the case. And the conclusion that was reached by Mr. Little and by our team was we were in that place. So this case would not have got to a jury because our professional assessment was that we were unable to satisfy that limb in view of that answer. So it's not so much the evidence that was given, it was that answer went to the heart of the issues and it was fatal to the case.
Can I
just add?
Just bring in Dame Emily.
May I just because I think there's quite a lot of elements here that we May I do it this way? Let's start with the evidence that you first had to charge Berry and Cash in April 24 with under Section 11C of the Official Secrets Act. What you had to prove was there was the actus reus, the guilty act, which was communicating information that might be useful to an enemy, and the guilty mind, the mens rea, for any purpose prejudicial to the safety or interests of the state, and that was an objective test. And at that stage, you had a statement, and it was from the Deputy National Security Advisor, dated the 22nd of November 23. So that's what you had. And the statement essentially said this: it proceeded on the basis that it would be proved by others that Berry had been recruited by the Chinese state as an agent, that he passed information from Cash to Berry, et cetera, all of that stuff. So he goes through all of that material and says, this is the material, this is how it was getting to China, this is who the people were who were getting it. And then the important thing, the original evidence that he gave, which you didn't get from any other source, was the evidence about the guilty mind, which was he made clear that the information was of the type passed that would be prejudicial to the safety or interest of the state, and he repeated that throughout the statement, right? So he's proving the guilty mind, others had proved the guilty acts, and what you didn't have in that first statement was you didn't have any evidence that China was an enemy, right?
We felt that, I mean, the high watermark of his evidence was his statement about the capability of China.
Are you referring to page 2, paragraph 6?
Yes.
Yes.
If I may I read it out?
Please do. Does it begin, the Chinese intelligence services are highly capable and conduct large-scale espionage operations against the UK and other international partners to advance the Chinese state's interests and harm the interests and security of the UK.
That's it.
So that's it. So you had that, but you had no more to prove at that stage that China was an enemy, right?
That was the basis upon
Right.
which we felt that we could
And the
maintain
law
the case.
at the time there was no definition within the Official Secrets Act as to who is an enemy, and these cases don't come up very often. And there had been this case called Parrott, which had come out before the First World War, which tends to show just how often these cases come up, which is not often. And in Parrott, what was said was that the law at the time was that again, Parrott said enemy is not defined, right? But that an enemy can be a country that one day might be at war. We might be at war with, which makes sense given it was the year before the First World War. So again, very vague, but essentially saying we're not going to say what enemy means. So that's your law at the time. You've got that one statement saying that the Chinese intelligence services are capable and conduct large-scale espionage operations, etc., etc. So that's all you've got. And what you're doing, aren't you, when you charge them, is you're thinking, right, we have these different elements, we're going to leave it to the good sense of a British jury to decide whether or not China is an enemy. At that stage, when you were charging, that was what your thinking was, wasn't it?
Well, at the stage we're charging, we had actually already begun and ultimately were successful a case based on threat to national security. And that's the case of reshape. I've referred to the legal ruling, but of course it was a criminal case. So
I mean, sorry. No. When you're charging the case, you charge on the basis of the law, right? And the law is what I've just taken some time to bring everybody through, which is the statute and a case called Parrott. And that's the law at the time, right? You may be sorting out another case that may or may not go to the Court of Appeal. It may or may not make some law. You don't know at that stage. When you're charging on the date that you did, right, which was April 24, you did it on the basis of the law then, not the law that you hoped might come at some stage in the future. You do it according to the law then.
yes, but
Right.
we took the view in both cases that the enemy requirement could be satisfied by demonstrating that the state, in one instance Russia, in the other instance China, was a threat to national security. And so that's the basis upon which we proceeded in this case.
I mean, you might have taken the view that you had evidence that China was conducting large-scale espionage operations against the UK and had recruited a couple of people who were connected with the British Parliament, and that by itself might be enough to persuade many a juror that China was an enemy, because it's hardly the behaviour of a friendly country.
The basis upon which we took the decision to prosecute was that. But what happened was that when in the earlier case, Rusev, that approach by the prosecutor...
No, I will give you a chance to move on. I just want to get the basis of this clear.
Yeah.
Because what I don't understand, you see, is that if you had enough evidence to charge, why you didn't have enough evidence to carry on with the case,
Yes.
and what it was that changed.
Yes.
And you say that the law was fundamentally changed by the case of Rusev, which made your evidence that you had when you charged not sufficient.
No, I'm not saying that.
What
If
are
I
you
may,
saying?
can I just finish
Sure,
my
yeah.
explanation? So the case of Rusev did confirm that you could base a case on the threat to national security posed by another state. But what it did was to also say that if you're basing a case on threat to national security, then you have to demonstrate that at the material time it was a current threat. The difference that Rusev made was that we needed to demonstrate in terms that the totality of the threats posed by China during the period of the offences made China a threat to national security. We weren't quite there on our existing evidence, and so we asked for more. We asked for a positive statement from an expert in this area. The DNSA wasn't giving evidence as an individual. He was drawing on all the resources available within government to produce his evidence. So we're asking him for that bit more. But it turned out not only to be a sticking point, but to be a critical difference.
But before we move on to the evidence that you got, or you didn't get when you tried to get more, I just want to know the basis upon which you were deciding that you needed to get more evidence. As I say, there might be many people, ordinary members of the public, who would be bringing common sense to this, this event through a jury, who might think large-scale spying on the UK, by China looks like the actions of an enemy to me.
Yeah.
So what changed it, you say, was Rusev. But don't you agree that the Court of Appeal said that it wasn't going to, this is in the case of Rusev, that they weren't going to establish a new meaning of enemy, that the term enemy should be approached in a common sense way. Now, lawyers know common sense way means that's why we have juries, because juries have so much more common sense than lawyers, frankly. And we need to get the jury to have a look and decide whether or not someone is an enemy. So Rusev is specifically saying we need to approach the idea of what is an enemy through a common sense way, i.e. we need to ask a jury. So we say that neither the approach in Parrott or Rusev was laying down a comprehensive test. They said that as well, as if you hadn't got the message from you need to ask a jury. They're now specifically saying we're not saying what a enemy is. Another country would be an enemy if the jury concluded that it was a country that Britain might one day become at war at. Well, obviously you weren't claiming, nobody was ever claiming that in relation to China necessarily. Or maybe you were, presumably you weren't. There was no reason why the term enemy should not also include a country that represents a current threat to the UK national security. That's also include. It's not this is the only way in which a country can be an enemy, is if they in future might be at war, or they represent a current threat to UK national security. They were specifically saying we are not saying what the definition of enemy was, so you should have just gone ahead and prosecuted it.
Well, I'm sorry. Absolutely, they were saying that there isn't a comprehensive definition. They confirmed that you can bring a case on the basis that a country poses a threat to national security. But they defined the ambit. If you're going to bring a case on that basis, they defined, as you've just read out, that there's no reason why you can't bring a case on the basis that at the material time it was a current threat to national security. So obviously, were to us, it felt that we had to be four square within the ambit of what they said, which is...
No, but they said that there wasn't a clear definition. They just gave you an example, just like Parrott had given you an example of what an enemy might be. Rousseff had given you an example of what an enemy might be. But you could also have just asked a British jury, is China an enemy, particularly given the way it's been behaving?
Well, as I've explained, the view that we took, and I will invite Mr. Little to add to this, but the view that we took was that our case wouldn't survive a submission of no case to answer, and so it wouldn't get to a jury. We took the view that we'd taken rather an expansive approach to the definition of enemy, if I may say so, by, in Rousseff itself, and now in this case, saying the legal test could be met by demonstrating that China was a threat to national security. The Court of Appeal said, we agree, but it clarified what would be required, and that was to demonstrate at the material time that China, in this instance,
you
was
agree
a
with me or
threat
not that
to national security.
That you see, you're slipping back into claiming that that was the definition that the Court of Appeal was giving, but don't you agree that it's not a definition the Court of Appeal was giving, because they specifically said they weren't giving you a definition. They said this was an example, and that it was up to the good sense of a jury to decide.
They said we can bring a case based on a threat to national security and define the ambit of what they meant by that, i.e. a current threat to national security at the material time. They did talk about a jury, but on the basis that there was some evidence to substantiate that. And our problem, if I may come back to this, was that our only witness on this issue was unable to confirm that at the material time China was an active threat to national security. So we didn't have the evidence.
You've got it in your first statement. You've got the Chinese intelligence services are highly capable and conduct large-scale espionage operations against the UK and other international partners to advance the Chinese state's interests and harm the interests and security of the UK. That sounds like a threat to me.
Current threat to national security at the material time. They did talk about a jury, but on the basis that there was some evidence to substantiate that. And our problem, if I may come back to this, was that our only witness on this issue was unable to confirm that at the material time China was an active threat to national security. So we didn't have the evidence.
You've got it in your first statement. You've got the Chinese intelligence services are highly capable and conduct large-scale espionage operations against the UK and other international partners to advance the Chinese state's interests and harm the interests and security of the UK. That sounds like a threat to me.
I think Mr. Little wanted to...
That was the basis upon which the charging decision was made, that it was a national security threat. I also accept that, depending on the evidence, threats to the economy, significant threats, could amount to a threat to national security. But we cannot get past, and it's unhelpful to try and ignore the clear words of the witness who was going to be called, who did not say to me, I'm not going to say that they pose a risk to national security, but they pose a really significant economic threat, which I do regard as a significant threat to national security. He wouldn't say that. And so it's critical, bearing in mind how we put our case, and I accept that the definition is not exhaustive, but the question is, what other definition could we or should we have used? We had always proceeded on a national security basis, and common sense, I'm afraid, is not enough if I do not have the evidence to establish properly, in an admissible form, that they did pose a threat to our national security, or some other route to allow me, not just with rhetoric, to say you can be satisfied so you're sure that they are an enemy. And that's the fundamental problem with the meeting on the 14th of August 2025, because the effect of that was a total roadblock to this prosecution, and that's my firmly held
May I just let this will be my last question and then I move on.
I need to move on.
This is my last one. You had 12 pages of evidence in the first statement of the various things, the various information that these guys had passed on to the Chinese. You know, you had and extensive, you know, example after example, and they had been recruited by the Chinese in order to give evidence to them, in order to advance the case of, in order to advance the national interest of China, and again being told that it was undermining the national interest and the security of the UK. It's not rhetoric, you had evidence.
That evidence was, as you can see from the terms of the statement, focusing in on another element of the offence, which is purpose prejudicial.
I won't ask any more questions.
Just very briefly, why didn't you put this to a judge? Was there any sort of downside to putting it to a judge, just to gauge their thinking on this?
Well, there would be no basis to do so. Once the prosecution formed the view that there is not a realistic prospect of conviction, we don't go and have that second guessed by a judge. That's the duty that's placed upon the director and all his prosecutors. I provide advice in that respect, but that in my submission would not be a proper way to prosecute the case, which would be to pass the buck to somebody else and let them stop the case. That's the importance of making these difficult prosecutorial decisions, which the DPP is entrusted to do.
I'm just going to bring in Lord Sedwell and then Lord Boateng. Can we hear you?
I ask the question while we're dealing with the technology.
Lord Boateng,
He's on.
The question that I have for you is this, and I recognise the difficulty and the complexity of this case and your role in it. But the threat goes beyond those excerpts that Dame Emily has helpfully read out to you, because the first witness statement also says, and I quote directly, its espionage operations, quotes, threaten the UK's economic prosperity and resilience and the integrity of our democratic institutions.
That's right.
So this isn't just a question of the economy and resilience. It goes to the heart of our national life, our democratic institutions. Neither of you have mentioned that in response to Dame Emily. So how do you deal with that? Because that would seem, on the face of it, to be the surest possible indication that we were dealing with an enemy, someone whose espionage operations threaten the integrity of our democratic institutions.
Well, as I mentioned earlier, we were satisfied on the basis of that first witness statement that there was a case to bring to court. But I'm sorry to keep repeating this, but it's such an important point that I feel I need to. That at the end of the day, on the 14th of August, the witness could not give us the critical evidence that was required by the Rousseau ruling.
Oh, no, because the Rousseau ruling doesn't deal with the issue of the threat to our democratic institutions in a way that in any way alters the situation that you faced when you made the decision to charge. The statement is very, very clear. A threat to the integrity of our democratic institutions. Mr. Parkinson, in response to the chairman, you made the point that senior people had to be consulted. Was it anything, who were those senior people, and was it anything said by them that led you to reconsider your assessment of the witness statement that very clearly states the threat to the integrity of our democratic institutions?
I apologise if I was unclear earlier. When I referred to senior people, I'm talking about the internal governance within the Crown Prosecution Service. The decision-making process involved only counsel and colleagues of mine in the Crown Prosecution Service. I did inform the Attorney General of our decision, but it was the purpose of the meeting was to inform him, not to consult him.
You informed the Attorney General of your decision when?
On the 3rd of September.
And when you informed him of that decision, was there any question about the threat to the integrity of our democratic institutions?
Well, he read counsel's advice. We had a discussion. I don't recall that particular issue, but the discussion was around the fact that we were unable to satisfy the enemy requirement for the reasons that I've given.
Even though the witness said that at that time there was a threat to the integrity of our democratic institutions.
Well, the witness was unable to provide the confirmation that we sought, that China was a threat to the national security of the UK. That was the basis of our case.
So something that threatens the integrity of our democratic institutions is not a threat to the national security of the United Kingdom?
Well, I know that you are hearing from him later today, and with respect, maybe that's a question to put to him, but the question that we put to him was, can you give us the confirmation that we need in order to continue with this case? And he wasn't able to do so.
Thank you.
Lord Sebel. You're on.
Thank you. Yeah, sorry. I need to be unmuted from.
Apologies for the bells, but we will continue working through. Okay.
Okay, thank you.
So, Director, thank you. Well, as you said, we'll be putting these questions to the Deputy National Security Advisor later. My question is a simple one. You've referred to the witness, but why did you choose only to have one witness, the Deputy National Security Advisor, on behalf of the government, as your only source of evidence on this question of whether China poses a national security threat to the United Kingdom?
Well, the choice was not made by us. The choice was made by those investigating the case, but he appeared to be the most appropriate person to provide that evidence. As I said earlier, this wasn't personal evidence. He was giving evidence on behalf of the state, and the expectation was that he would draw upon all appropriate sources within government in order to frame his evidence. So he was in effect an expert. He wasn't what I might call an observational witness. An observational witness is someone who witnesses an assault or a threat. He wasn't that type of witness. He was an expert. His job involved providing advice to Cabinet on these issues. He seemed to be the best placed person, so we were told, and we were happy to accept that. I think the other thing, because questions have been raised about whether we might have drawn on other sources, and in my letter I tried to set out not only why he was considered to be the most appropriate person, but why it would have been very undermining of our case if we'd produced another witness who was contradicting him. We don't think that the judge would actually have allowed it. But in the simple answer to your question really is that this was the witness produced to us by the investigators, and he seemed to be the most appropriate person to give that evidence.
So I understand that, Director. By the way, as I should just say for the record, I used to be the National Security Advisor, and indeed Mr. Collins used to work for me, although not as deputy. He was in a more junior position.
Yeah.
But if I can just pursue this point.
Of course. Yeah.
You've said in correspondence, etc., rightly, that you are independent of government. And so Mr. Collins is, as we've seen in his various witness statements, representing the government position. Of course, as the most appropriate person, he's there essentially as an institutional representative, not in a personal capacity as you have set out. But what you are seeking to do is demonstrate objectively to a jury that China is a national security threat to the UK, independently of government. because he has reflected the government's position. And you have other evidence, for example, ISC, Intelligence and Security Committee reports, government responses, statements by various directors general of MI5, statements by people like me, former national security advisors, etc., all of whom you could have assembled to demonstrate that China is a national security threat to the UK, notwithstanding a potential concern that the government has chosen, clearly somewhat to your surprise, not to use that language themselves, presumably as a matter of government policy. So why did you, since you are independent of government, why did you not double down on that independence and secure other witness testimony that would have enabled you to demonstrate that test had been passed to a jury for the reasons Dame Emily set out?
Well, as I've said, producing other witnesses that contradicted our witness, who we were bound to call, by the way, because we needed him to establish the prejudice element of the offence, may not have been allowed, but would have undermined our case. But he did refer to the integrated reviews of both July 2021 and 2023, which set out the overall government position in relation to China. And the integrated review of 2021 didn't refer to China as a threat. It referred to China as a systemic challenge that China poses to our security, prosperity and values. And the Deputy National Security Advisor also referred to the fact that the UK wished to pursue a positive trading relationship with China, as indeed did the integrated review. So he did reference both those reviews, which seemed highly pertinent. But I come back to the point that the Crown is indivisible, and he represented the state view. He could draw on all sources. I assume he did. Most of what he says in his witness statements is actually drawn from statements of government policy of one kind or another, and those referred to China not as a threat, as they did in relation to Russia, by the way, but as a challenge, and that was insufficient.
So I do understand that point, Director, but those are statements of government policy, not statements of fact. That's the point. Integrated reviews are statements, public statements of government policy, and like all public statements of government policy, they are encompassing a range of different objectives. The simple truth with China is that it is both a national security threat and an economic opportunity, and various governments have been seeking to reconcile that tension for decades. And the fact that a government policy statement uses different language is not the same as a legal test of whether at least part of that is that China is a national security threat. And as I said, there are ample other sources of evidence associated with the Crown that state that China is a national security threat. And I entirely understand your point about the risk of contradicting the DNSA. But what would have happened, presumably, is he would have been cross-examined, including on the evidence that Dame Emily read out and you were discussing with her earlier, alongside other evidence from former directors general of MI5, or indeed that you could simply put on the record, because these statements are on the record, and the jury could have then made a judgment as to whether government was ducking the question of China as a national security threat for wider policy reasons, which is not the legal test. It's a government policy test, and that's what we're trying to get to.
I'll ask Mr. Litter in a second to come in on what would have happened at trial. But if I may say so, I completely agree with you. We were looking to the DNSA to provide evidence of the actual threat. I've said this in my letter, not what government policy was. But it appears he was unable to go beyond the government policy position. In the conference on the 9th of September, he said to Council that in relation to the 2021 to 2023 situation, he would not say that China was an active threat. And he went on to say successive governments had declined to categorise it as such. So we were looking to him to provide evidence of what the threat was in actuality. But in terms of what he was prepared to say, he was not prepared to go beyond that. But
That's my point. He was stating government policy, and you were asking for an evidential test. Yes. He was unwilling to go beyond government policy and thus provide you with your evidential test, and we will interrogate him on that in the later session.
Yes.
My question is, knowing that, why did you not choose to draw on alternative sources of evidence, including from state servants, that did meet that evidential test? Because what it appears to be the case is, in effect, a government policy became your test rather than an evidential test.
I understand the point entirely, and I agree that looks like the position that we had reached. But we were bound to call the DNSA. He had to be called.
Of course.
And so he would have faced that question. And you confirm, etc. And he would not have been able to give that confirmation.
Well, he might have found under cross-examination that he had to go further than he was comfortable doing, because you would have had a range of other evidence, including from Directors General of MI5, including from the Intelligence and Security Committee, including for the government itself in response to the Intelligence and Security Committee, including his own initial witness statement, which you could easily have said, well, you know, Mr. Collins, you may now say you're not willing to say that, but all of this evidence demonstrates that that the government has accepted that China's national security. Isn't that the case?
Yeah. Can I bring in Mr. Little, because he's the expert on what happens in trials?
If a criminal trial was an inquisitorial process, yes, but he was my witness, so I couldn't cross-examine my witness about inconsistent statements from his own, from other emanations of the state. That's just not permissible in a criminal trial. Nor, in fact, can I call witnesses to impugn the credibility of my own witness when he is the Deputy National Security Advisor. This is not the position. This is straightforward criminal procedure. This is not the position of two eyewitnesses to something that takes place, and I can say to the jury, you can accept this witness on A and B but not C because they're mistaken about that for the following reasons. We're simply not in that territory, and I'm afraid the principle of indivisibility is a real problem for the prosecution in this case. Were it not so, and I could have put him into the witness box and cross-examined him myself, but that's simply not how a criminal trial works. I would have to have asked him in examination in chief what the position was in relation to the threat, because it would have looked awful if he'd been just cross-examined on that. And he would, I am sure, have been consistent with what he told me repeatedly in conference. And he didn't tell me in conference, look, I could say so much more in private, or I could say so much more about the threat, but I can't because I have to just set out what the policy is. So having made the decision to rely on this witness, we could not give him away. He's a witness of truth. I have no reason to doubt him. I am forced to call him, and it is open season for the defence. And my view was that the judge would not in those circumstances have allowed us to call inconsistent evidence from no doubt very eminent and experienced witnesses who would have been able to comment on it. And that is a really important issue which everyone has to understand the realities of a criminal adversarial trial process. I would have to have called this witness first, and that would have been fatal.
Right, I'm just very conscious of time, and we're going to run out of time.
I'm going to be very brief.
I'm sorry, look, I'm going to bring in Dame Emily.
I've got one question. Because you've said that you decided to rely on this witness, and he had made it clear from the outset, before anyone was even charged, that he was not going to call the Chinese an enemy because of government policy. government policy, being Conservative Party policy at the time, but it continued throughout the time of his having had statements taken from him. Yeah. That's correct, isn't it?
It is correct. And we were conscious of that when we made the decision to prosecute. But we concluded that we would be able to prosecute on the basis of threat to national security, and you didn't need to use the word enemy. By basing a case on threat to national security, we would meet the legal requirement. So it's not a question of using a word, it's can we satisfy the legal requirement, and we felt that our case did at that point.
Isn't it clear the government just wanted to collapse
Gavin,
the case?
Gavin, I'm sorry, we have to move on. Okay. Edwin Morello.
Thank you, Chair. Just quickly so I'm clear on the timeline, you mentioned before that you had met with Mr. Little and the prosecution team and key advisors in the CPS before you made the decision not to proceed with the case. Do you make that decision, or do you make the decision based on the advice of others?
Well, the decision was actually made by the head of the special crime team, and then reviewed by others, including by myself. But the decision making took place at a lower point in the organisation, but it was endorsed by me. I mean, in practice, obviously, you know, we prosecute 450,000 cases a year. I see only a tiny number of those. I am cited on the most complex and sensitive cases, and I can intervene.
But in practice, you are reliant on the advice of others.
Yes, but having said that,
at the risk of the Chair's wrath, I must ask the question and allow others to ask the...
May I just complete my answer? Obviously, given the volume of cases, I do rely heavily on my colleagues, but with the complex and sensitive cases that come to me, I do look very carefully at them, and from time to time I do push back, and I ask more questions, and I test and I challenge. And in this case, I considered it very carefully indeed, and I concluded that the right decision had been made. I think it's important to say that.
In your view, does the National Security Act 2023 make it easier to prosecute espionage cases like this?
Yes.
Thank you. Sir Gavin.
It's very interesting, actually. I was absolutely fascinated to hear about what you were saying about, because you thought it'd be quite easy to establish an active threat to national security. Is that correct?
I think we felt that it followed from everything that had been said already.
Did you actually, when you were speaking to the government, did you explain to them the implications as to, you know, the statement as it stood, as to how that would impact in terms of the ability to prosecute?
So if I may go into just a little bit of detail, I don't want to give a long-winded answer, but
as brief as you could.
I will. I promise you. We made the request. It took some months before we had a substantive response, but on the 10th of December 2024, Council met the lawyer who'd been designated to act for the DNSA and to discuss what evidence might be given. I've seen the notes of that meeting, and it was made clear that the evidence we sought was critical. The language used was, we don't want to get into a situation in which the case is dismissed at half-time, which is the phrase lawyers use to describe a submission of no case.
So Mr. Collins would have understood by not that China was an active threat to national security. By denying that to you, he effectively had the ability to collapse the case.
Well, I assume that his lawyer explained the significance of his evidence. At the very latest, the DNSA would have understood this, because at the meeting on the 9th of September, it had already been made plain that the case could not proceed because he was unable to give the positive answer that had been sought. And so the context of that second meeting with Council, it would have been absolutely clear to him the importance of his evidence. But I'm sure that he really ought to have understood that before then.
And so he would have been absolutely clear that the case would have collapsed in that sort of position. And he would have also understood that even though there's plenty of people within the security establishment that would have agreed with the fact that there was an active threat to national security, you couldn't effectively bypass him. So in essence, there is almost an active government policy to collapse the case.
Well, I'm afraid I can't speak to what he thought. I know you're going to be speaking to him. All I can say is that he was unable to give us the evidence that we needed.
Because he would have been, a little bit as Mr. Little was touching upon, it was quite clear that with him sticking with that position, no matter who you brought forward to the jury and the judge, effectively the whole case was going to be thrown out.
That is the case. I did say this in my letter, but I think it's worth just making this point. All routes by which we might establish that China was an enemy were closed. We couldn't go down the route of threat to national security for the reasons we've discussed. He had said we were aware that he was not prepared to say that China was an enemy or a potential enemy. He was not prepared to say that China was opposed to or hostile to the interests of the UK. So there were no other options open to us. The case had to end.
You sort of closed every avenue that you could possibly go down.
Well, the consequence of the evidence he was unable to give was that the case was at an end.
Thank you ever so much.
Paul Robertson, briefly.
Thank you.
You don't want to come in? Okay. Dame Karen.
Thank you very much. There was a point that the chair made at the beginning of the session that hasn't been answered, and it leans on from the questions you've just received, which was, you say there was no other avenues you could take, but could you not have gone through a different charge, espionage perhaps?
We considered all potential charges, and this is where we ended up. But maybe I could ask Mr. Little, because I know he was advising on this.
Yeah, I mean, we gave careful thought as to the evidence that we had and whether we could change horses as far as the offence is concerned. And I want to make it perfectly clear that if I thought there was any way in which I could properly have prosecuted this on the evidential stage using another provision under the Official Secrets Act or one of the other Official Secrets Act, then we'd have gone down that route. The last thing that I wanted to do was turn up in front of the judge in charge of the terrorism list and offer no evidence in the case for all of the reasons that are obvious and that the director has already raised.
You must lose it.
Okay, thank you. So when we met previously and in response to questions that we've put, you've been very clear that what you needed was some form of a statement around the policy of the government at the time the offences were committed. Is that correct?
Well, what we needed was evidence that there was an actual threat. So we weren't asking for statements of policy. We were asking for the witness, as Lord Sedwell pointed out earlier, what we needed was evidence of fact that in actuality China was an active threat at the material time.
So the final statement, the description of China, is taken from the Labour Party manifesto. Did that undermine the case? Was that the fundamental problem?
I obviously have read in the press that there's similarity between the statement and the Labour Party manifesto, but we were unaware of that. And
that wording was the wording that meant you couldn't say that China was a threat.
No, to be clear, the problem has always been that those three witness statements were insufficient to enable us to prove the case. We needed that extra element which couldn't be satisfied. So I'm not criticising the content of the witness statements. The point that I made from the outset is that we needed more. And what was missing was a critical element.
We will ask those questions to the NSA shortly, but was there any government official, special advisor, minister or anybody that was informed prior to 1st of September that the case was potentially going to fall, potentially going to collapse?
Not to my knowledge. So the timing is that the Attorney General was informed on the 3rd of September. Prior to that, he was aware that there were issues, as he'd mentioned in his own letter.
So he was aware prior, but he didn't know that you were not going to proceed with charges?
That's right.
Okay. Okay, but he knew prior to 1st of September that there were issues with the case.
We gave him regular updates, and we explained that we were looking for a further statement from the DNSA.
And the final question. In the correspondence we've received, that the after the request for the third witness statement was made, there were further emails from the CPS to clarify the ask. What clarification was required?
I think the further emails were prior to the third witness statement. CPS sent an email on the 10th of July, and the third witness statement was the 4th of August.
4th of August.
Yeah.
And Mr. Little, you met on the 14th of August, was that
Yes.
right? Okay, so it was the 4th of August was the witness statement, 14th was the was your meeting, and then the 22nd of August is the advice that you couldn't proceed, just so that we've got all the dates absolutely clear.
Yes.
Okay, thank you.
Lord Hutton.
Can I just come back to this point about who knew what when? When was the Deputy National Security Advisor told that if he didn't provide this extra bit of evidence about China being an active national security threat, if he didn't provide that statement, that the case would collapse? Was he told that?
Well, he wasn't. That wasn't the nature of the conversation. On the 3rd of September.
Sorry, why wouldn't he have been told that? It seems the obvious question to put to him.
May I just simply want to reframe, if I may, what happened. So on the 3rd of September, as I've mentioned, I informed the Attorney General of our decision. Then later that day, I informed the Cabinet Secretary of that decision and explained the reasons for it. Then the DNSA came in at the conclusion of that meeting, and I informed him of our decision. It was clear from the conversation that then developed that he felt he could offer more. He said that the meeting with counsel had been brief. So I reached the conclusion that no further steps should be taken in this case until the DNSA had had a further opportunity to meet with counsel. So that's the way the conversation developed. And I said, no communication, please, to anyone, because an issue has been raised that there may be more to be said. So that happened, and the second conference with council took place on the 9th of September. But the DNSA was obviously aware of the context of that meeting, which was that we'd been on the point of offering no evidence. And so he would have understood the reason for the conference and the reason for the question.
So effectively, sorry, Mr. Little, did you?
Can I just add that in the way you articulate it, I can understand why you do put it in that way, but I would never have expected a witness to effectively almost have a gun put to their head and said, you need to say this, otherwise we're going to drop the case. You can understand what the inevitable effect and how that would be used if he then said, oh, well, they do, then we would have to have disclosed the terminology used. But your real point is, was he on notice more generally about the impact without there being a threat? I took the view, certainly on the 14th of August, that he understood what he was telling me. It was relatively brief, but actually the issues are pretty narrow that he had to deal with. It's a one-question answer, and he was absolutely clear in the second meeting on the 9th of September because it had already been raised. And although some of the language used was not identical to the previous meeting, the substance and effect of it was identical as far as my conclusion was concerned.
So he certainly knew this case was going to collapse.
Well, you'll have to ask him, but I'd be surprised if he didn't. I think I could.
Just very briefly on this thing about other charges, could you just explain to the committee why you didn't consider a charge under the Criminal Attempts Act?
In respect of which underlying...
The espionage activity of these two people, because clearly from the evidence that we've seen, they knew they were spying. They talk about, we're in it now, we're spies now. Why did you not think that they were attempting to breach the Official Secrets Act? Because it looks to me like they were.
Well, we'd still have to establish, depending on what route you're taking through the Official Secrets Act, we'd still have to establish with an attempt that there was an enemy underlying it for a Section 1 offence under that legislation. So
Yeah, but isn't... Sorry, I mean, obviously...
I don't want to give
I don't want to
sort of legal advice on the hoof.
I really don't want to do that. But my understanding of the Criminal Attempts Act is that really, if the two people who were charged thought they were actually contravening the Official Secrets Act, that was enough to bring a criminal attempt prosecution.
No, I don't think it's as easy as a yes or no answer to that. It would depend on how that was put. But I can't see how we could have maintained an attempt here to perform what would be impossible if I didn't have any element of them being an enemy. There are sometimes lateral ways in which one can deal with certain inchoate offences in relation to conspiracies and so on and so forth, but
there was a conspiracy. But there
like
certainly was a conspiracy.
They were conspiring together, weren't they?
Okay.
Well, no, I do think this is rather important.
yeah, well, the question is, what
why
would they
didn't you charge him with conspiracy? Why didn't you add that to the indictment?
Well, but we would. They would still have had, in this basis, they would still have had to have been an enemy as far as that was concerned.
But by the first statement, there were espionage operations which threatened the integrity of our democratic institutions. What more do you need?
Well,
these men were conspiring to do that. Well, that was the evidence that was contained in the first witness statement.
Well, the problem that we had, and I'll go back to it again, is the unequivocal position that the witness took in the meeting on the 14th of August. And it's important that people don't shy away from that. I was at close quarters to him. I looked at the witness in the eyes, which is something that I've scarcely ever done, absent a expert such as a pathologist. It just doesn't happen. And it happened because of how important this case was, but the effect of that discussion was, in my view, terminal as far as the charge was concerned, and we did reflect upon alternative offences, but concluded that there wouldn't be a realistic prospect of conviction in relation to them.
An espionage case couldn't have been brought because of what the witness said.
Yeah, that's the view that we took, yes.
And Chris Wilmot, Cabinet Secretary.
Thank you for joining us. Sorry we're running slightly late, and just to forewarn you that there is the possibility of votes. We're going to hopefully conclude this before those votes get called, but hopefully we'll be able to maintain choracy through that time. Perhaps I could start with you, Matthew Collins. How do you feel about the collapse of this recent case?
Disappointed. I have worked at the cutting edge of national security issues for the last 10 years, of countering terrorism, countering state threats, have been at the heart of successive government responses to Russia's invasion into Ukraine. I very, very much wanted to secure a conviction in this case. A lot of people put a lot of effort into investigating the issues and building the evidential case. When I agreed to be a witness, I knew it was going to be tricky because of the nature of the Official Secrets Act in 1911. But I was willing to put myself forward to give evidence in the best possible way to secure a successful conviction. I was expecting to provide evidence in an open court. I have to admit I wasn't quite expecting to provide evidence at a select committee hearing, but I'm very happy that I have the opportunity to set out what I would have said.
So one thing I just wanted to ask you, we've heard in recent months about the current government's mantra of cooperate, compete and challenge. I'm just keen to know, was that a mantra that was prevailing at the time that this spying was alleged to have taken place?
No.
Government?
Between 21 and 23. So the mantra of the Labour government hadn't necessarily been formulated at that point. I was very clear when I agreed to be a witness that I would do so in line with the government policy of the day. As a civil servant, you would expect no less.
What was the prevailing attitude between 21 and 23?
Well, you can see several quotes from both the integrated review that was published in 2021 and also the integrated review refresh that was published in 2023. I can read some of those excerpts if that would be helpful, but I think they stand, they've been published and have set quite clearly the framework of the previous government's policy towards China.
Thank you. Baroness Tyler.
Thank you, Chair. My questions are mainly for you, Mr. Collins, and really flow from the discussions we've had in the first session. So just to kick off, when you gave your initial witness statement, which I think was back in December 23, the one in which you described China, I think, as an epoch-defining challenge and also talked about large-scale espionage operations against the UK, were you aware of the specific offence that the CPS were considering under the Official Secrets Act?
At the time of
at the time of doing
that,
of submitting that first statement. And sorry, if I may just follow on that. And were the specific evidential thresholds for this particular offence explained to you?
So a couple of things. So you've quoted the integrated review refresh, which I put into my witness statement to demonstrate what government policy was at that time. I had conversations with my own team, Cabinet Office lawyers and external counsel in the formulation of the first witness statement. We were clear about the OSA 1911 provisions that would be required, and the witness statement was put together specifically to try to ensure that at that point we could support a successful charging decision.
Right, and sorry, just to clarify for my benefit, were the CPS involved in those discussions you've just talked about?
Not at that point, no. Discussions happened with counter-terrorism police, with my team and with my legal team at that point. I also... Should I continue?
Yes. If we could try and continue, if you're able to stagger your timings to vote.
Should I wait for the bell to finish, or should I?
Well, if you're able to persevere, that would be great.
I was just going to say that discussions with those sets of people, with counter-terrorism police, with my legal team, my own team, and then I consulted with the Cabinet Office PUS, the National Security Advisor at the time, and then cited the then PM on the witness statement.
Right, but you feel that you were clear what those evidential tests would be for the specific offence that was being considered?
I understood that we were using an archaic piece of legislation. One of the reasons that I was asked to provide evidence, both in this case and the Rousseff case, was to help fulfil the thresholds, the evidential thresholds, which would enable us to secure a successful prosecution.
Okay, thanks. I'm just going to press on. I'm sorry, I know it's a bit tricky. If we could turn now to your second and third witness statements, can I ask you why you did not explicitly state that China's activities constituted a national security threat? Just what did you feel prevented you from making that statement?
So in all of my statements, what I was trying to do was to demonstrate the range of ways China poses threats to our national security. In the first witness statement, I set out the range of espionage threat. In the second and third statements, I set out the cyber threats, the economic security threats, and the threats to our democratic institutions. What I didn't do was to define or label China as a threat in a generic term. But what I did try to do was to demonstrate the full range that they were posing a range of national security threats to the United Kingdom.
Okay, so if I just to help the committee on this point, because it is absolutely critical, was it basically that your decision not to say to describe China as a national security threat was a sort of a judgment call that you came to at the end of setting out all the things you mentioned in the statement? Was it your final sort of judgment call?
As I mentioned in my response to the chair, when I started this process, I was always clear that I would need to be in line with government policy at the time. I've quoted extensively the range of government policy documents at the time. The government at that time did not go so far as to label China a threat in the generic sense. It did say in a range of ways that there are threats that we need to protect ourselves from. I know that is a very fine distinction, but what I tried to do was evidence in all three of my witness statements the range of threats that China poses to our national security.
So in the way that you actually worded your statements, you were explicitly taking account of what government policy was in relation to China?
As you would expect of a civil servant.
Right. So could I just follow a couple of follow-up questions then? Is what did the CPS precisely ask you for when it was requesting the two further statements? What specifically did they ask you to provide in those two further witness statements?
So they were asking me to provide evidence of national security threats as it became clearer, and particularly towards August and then into September of 2025, it was clear that they were looking for a precise formulation of words.
And Matthew, sorry, just to come in, was that they were asking for a view, or were they asking for a statement of fact?
So they were asking for my evidence as Deputy National Security Advisor.
Asking for your judgment?
Sorry?
They're asking for your judgment?
They were asking for my view as Deputy National Security Advisor, providing evidence in this case. I was clear from 2023 that what I would provide in order to support a successful prosecution would be in line with government policy at the time. I also tried to demonstrate, as you've seen in my witness statements, a range of ways that China poses threats to our national security.
Ernest Tyler.
Okay, just to pursue this point a little bit further, I just need to ask you this. Were you ever asked by anyone to ensure that your evidence did not establish that China was either an enemy or a threat to national security at the time of the offences? So no one pushed you to say the things you said in the way you said them?
So, just quite clear, and hopefully my letter set this out. There were a number of people who were involved in the formulation of my first witness statement. My team, counter-terrorism police, legal advisors. I sought clearance from the then Cabinet Office Permanent Secretary, the National Security Advisor, and I cited the then Prime Minister. After the charging decision, I was told that I wasn't able to share my witness statements because it may pervert the course of justice. I was a witness in a criminal case. I took that obviously very seriously, and so the preparation of witness statements 2 and 3 were done by that same small team of within NSS and with my legal advisors in consultation with counter-terrorism police.
Right, and did you know or did you suspect that the trial would actually collapse if you did not yourself label China as an enemy or a threat to national security in your witness statement? And if you had have been told that, would you have been more explicit in your statement?
So the first time I became aware that the trial might collapse was when I was asked to join the Cabinet Secretary's meeting with the DPP on the 3rd of September.
Right. Thank
Mike
you.
Martin and then Lord Robertson.
Yeah, thank you, Chair. Mr. Collins, if I may, the questions will be to you. So you've been very clear that at the beginning of the process, you were only able to give evidence on the basis of government policy. Would you say it's fair to say that that was your evidence? Your evidence was what the government policy was?
So I was able to draw from a range of sources. I was able to draw from the evidential bundle that operational partners had pulled together. But in describing that through my witness statements, I was clear in the formulation of that in the autumn of 23 that as a civil servant, I would be able to give evidence only in line with government policy at the time.
Okay, thank you very much. And in your view, I mean, you've got this great perspective because you've straddled both governments. With respect to China, and particularly this idea of whether or not China is a precise wording, an active threat to national security, would you say there's any difference between the policies of the Labour and previous Conservative governments?
I wouldn't say there are huge differences. No, I think there are differences in points of emphasis. There are definitely differences in the language that is used.
Could you give me some specifics, please?
Sorry?
Could you give me some specifics of those differences?
Well, I would say that the Labour government at the moment has been quite clearly wanting to ensure that it engages with China. However, the previous Conservative government also wanted to engage with China. A former Foreign Secretary travelled to Beijing for a series of meetings, and the Prime Minister met Prime Minister Li, I believe, in 22, although my memory might be failing me on the specific date of that meeting. But there are degrees of emphasis different, but I wouldn't say there's a huge amount of difference.
Thank you very much. So essentially the same policy with respect to China, or with respect to this specific question. And you were very clear at the beginning that you could only give evidence, if you like, through the lens of government policy. We've established that substantially the government policies didn't change either side of the general election in 2024. And you're nodding. I'm just going to say that because then it will go down on the written record. Now, we've just had the Director of Public Prosecution in front of us, and he was very clear that the CPS needs statements of facts. They don't actually care what government policy is. They need statements of fact. So the fact that you were clear at the very beginning that you'd only give evidence through the lens of government policy, do you think actually that the CPS made a mistake in calling you as the star witness? Because you could never actually give a wholly factual account of whether China was an active national security threat, because you could only give that evidence through the lens of government policy, which the CPS was not interested in.
Could I butt in at this point? Because I watched the previous hearing. I don't think the DPP at any point said he didn't care what government policy was. I don't think he used that phrase.
No, you're right, he didn't. But he did say we were only interested in what the facts were. So, Mr. Collins, if I could put the question to you, do you think that the CPS made an error in calling you as a witness to give facts about whether China was a national security threat? Because you was very clear from the beginning, you've told us that you could only give evidence through the lens of government policy, which didn't really materially change between the Conservative and Labour governments.
So I don't think it was incorrect to ask me to be a witness, given the position that I hold, what I see through the intelligence picture, what I see through the security brief, and the fact that I'd have advised successive governments on those threats. I can say very clearly what I was able to say. And what I was able to say is that China poses a range of threats to our national security. I was able to say that these include espionage threats, cyber threats, threats to our democratic institutions, threats to our economic security. I would be able to say that these threats are very real and persistent, and that operational partners are dealing with them on a daily basis. I also, incidentally, articulated all of that in my witness statements. All of those examples are in my witness statements.
Yeah, and additionally, sorry, could I add an additional point? I mean, as the DPP made clear, particularly in his exchanges with Ms. Thornbury, the original witness statement met the bar for prosecution. So the question of whether Mr. Collins was an appropriate witness, well, as I say, witness statement 1, as the DPP made clear in your previous session, met the bar for prosecution at that time.
Lord Robertson.
Yeah, Mr. Collins, I don't doubt your good intention, and I'm quite sure you are disappointed that this case did not pursue. But I read, if I may, briefly, that your conclusion, the first witness statement which has just been mentioned, which is the suspect's alleged activities were prejudicial to the safety or interest of the UK and would be passed directly to the Chinese state. Now, something changed between December 2023 and not having a... This document says they're spying. They're spying. So what changed? Why did you change your mind?
I haven't changed my mind. I stand by absolutely every single word.
Apparently you said to the CPS you'd be unwilling to describe China as a threat to national security, which is exactly what you said in your first witness statement.
I stand by absolutely what I've said in all of my witness statements. I said that in all of the case conferences that I had with the CPS in preparation for the case. I was very clear in what I just said, what I would be able to say about the range of threats that China poses to our national security, including the espionage threat that I mentioned in my first witness statement.
And again, the DPP in the previous session was very clear on this point as to what he considered changed, which was the second case, the Rousseau case. He set that out in quite considerable detail in the exchanges. So the straight answer from the DPP on what changed was the judgment in the Rousseau case. Now, obviously there was some debate between people much better qualified than I on exactly what that case meant, but he was very clear that that was what was changed, not Mr. Collins's evidence.
Sorry, just to quote from my third witness statement.
Yeah, but I'm not interested in the third one, I'm interested in the first one.
And I reiterate it in my third one. By way of specific demonstration of the active espionage threat that China posed to the UK between 21 and 23, in March 24, the UK government identified a pattern of malicious cyber activity by Chinese state-affiliated organisations and individuals targeting democratic institutions and parliamentarians as part of large-scale espionage campaigns that had taken place during that period.
Yes, and this is also the statement in which you, rather surprisingly, quote the Labour Party manifesto.
Well, I was asked to include reference...
Well, asked to include it.
I was asked...
Well, that's what I wanted to get to grips with.
Okay. I was asked to include a reference to the new government's policy by counter-terrorism police for fear that there would be a wedge driven between my witness statements and the new government's policy. I did that. And just as a point of fact, I drew from an answer to a parliamentary question rather than the Labour Party manifesto.
So there was pressure put on you on this?
No. I was asked by a CTP, as I was throughout all of my witness statements, to provide evidence in support of the case to secure a successful prosecution.
Edwin Morello, briefly.
Mr. Collins, given the range of threats to national security that you outlined in your evidence and the actions of espionage that you outline across your evidence, are these the acts of a friend or an enemy to the United Kingdom?
Well, we're going back to the questions previously. Successive governments have not framed our relationship with China in those terms. And therefore, in my witness statement, I did not frame the argument that China was an enemy. As you've seen, I removed that from a draft in my first witness statement prior to the charging decision.
Just in the previous session, Tom Little just said that he looked you in the eyes, Matt Collins, on the 14th of August and you made it clear that you would not stand up in court and say that China was a threat. Is that your recollection of that meeting?
So my recollection of the meeting on the 14th of August, and actually it was very consistent with subsequent meetings on the 3rd of September and then again the 9th of September, was that I would set out the range of threats that China poses to our national security, as I have done in my witness statements.
Okay, thank you. Can we move on? Baroness Fool.
Thank you very much. There's been a lot of interest about a meeting that you had with Sir Oliver Robbins on the 1st of September. From what you said early on in this session, you heard that there was a collapse of the case by the 3rd of September, so those are two near events. So, Mr. Collins, starting with you, you did attend a meeting. Who else was there, and did the case come up?
So the meeting on the 1st of September
with Sir Oliver Robbins
involved a range of different civil servants and operational partners. It was to discuss a range of China issues, including the handling of this case. There were at least 4 lawyers in the room who ensured that there was no discussion about the evidence that was going forward in the case.
But did you discuss whether or not, if the case went forward, that would affect adversely your relationship with China?
It discussed a range of different scenarios and how we would handle them.
So you did have a discussion about whether or not, if the case did go forward, it might have an impact on your relationship with China?
So, as I say, it discussed a range of different scenarios and what we would do to ensure that we managed our diplomatic relations, not just with China, but with other partners as well.
And 2 days later, the case collapsed. You were told that the case had collapsed.
So, the Cabinet Secretary was informed that the DPP would not take the case forward. I was asked to join that meeting at the end to explain to me why.
So you didn't know at the time that the case was going to collapse. Did you talk about whether or not to describe China as an enemy was something that you needed to say to make the case work?
No, as I say, there was no discussion about the substance of the evidence in that meeting.
So Chris, were you at the meeting?
I was.
And who else was at the meeting? Was the National Security Advisor there as well?
The National Security Advisor, yes, was there. The meeting was exactly as Mr. Collins described. It was to discuss different scenarios and how they would be handled. It was not to discuss the evidence in the case, as Mr. Collins has described, and we've also described in our written evidence. Lawyers were present to ensure that the discussion stayed where it was supposed to be, which was how would we handle different scenarios in our relationship to China. As a number of people around this table will and on screen will know, holding meetings within government that discusses different scenarios and what the government's response would be to different things happening is completely common, both within the national security world and within other types of policy.
At the time of that meeting, were you aware of the fact that the case needed some stronger language in order to...
No, we didn't discuss the nature of the case at all. It was exactly as I've described. It was about handling. I knew that the DPP's intention, and I use the word deliberately, was to present no evidence at the meeting on the 3rd of September that the DPP described, though as he's described in his both his written evidence and in the evidence that he gave you, he did not confirm that decision till the 9th of September. I mean, also in his evidence, as you heard, the internal decisions within DPP as he within the CPS as he described it were prior to the meeting on the 1st of September from his evidence to this committee.
So Chris, can I just have clarity on the fact that there was no sense that the scenarios which you just said that you did go through in that meeting of adverse impact on the relationship with China had the case gone forward did not impact the decision 2 days later for the case not to go ahead?
No, and the Crown Prosecution Service was not present at the meeting, and the all communications with the DPP and the CPS about ongoing cases are handled within very strict guidelines by the Attorney General's office. I know you're talking to the Attorney General tomorrow, and I'm sure he will go into considerably more detail about exactly what can be discussed in what circumstances, but it's all set out in the AG's letter, and those rules were all followed.
Thank you. And just one more question, Mr. Collins, back to you, just so we have absolute clarity on this for the committee. You did not change your wording around the enemy, the description of enemy after the meeting on the 1st of September, before you heard that the case was not going ahead on the 3rd?
Definitely not. The language about enemy, as I articulated in my response back to the committee, was taken out of my first witness statement before it was submitted in December 2023 to be in line with government policy at the time.
Yeah, and sorry, just on that, I mean, just as a point of fact, all 3 witness statements by Mr. Collins were submitted well before the meeting on the 1st of September, and there was no witness statement after the 1st of September.
Okay, and Mr. Collins, when did you have the conversation with the counter-terrorist police who asked you to add that line, that clarifying line about the government policy on China of the day as opposed to the previous government?
So it came in during the various different back and forths that we had when I was asked to provide the second and third witness statements. I reinserted it in the third witness statements because my legal team suggested that we needed to be as consistent as we possibly could be in all 3 witness statements.
Thank you very much.
What happened?
Matthew, can I just go back to something you said earlier? And by the way, I want to thank you for what you do to preserve national security in our country. You said you were disappointed by the dropping of the case, but you couldn't have been surprised that this was going to be the outcome, could you?
So I was a bit surprised, actually. I always knew it was going to be a challenge. When we discussed it with my team and with operational partners way back in 23, it was always going to be a more of a challenge in this case than the other case that I gave a witness statement to. That's because of the nature of the actor and the nature of the incidents in question. But throughout the period from the submission of that first witness statement until I was informed that the intention was to drop the case, I was trying to ensure that we could support a successful prosecution. And so I was somewhat surprised when I was told on the 3rd of September that the intention was to drop the case.
But you do identify a whole range of threats that Chinese espionage poses to the security of the UK. No one's disputing that, and we're thankful that you pointed all that out. But clearly CPS wanted something extra from your witness statements that you felt unable to give, and your response to that is that you couldn't give that extra statement because that was not the then policy of the government in relation to China, as it hadn't been in relation to the previous government's policy in relation to China.
I was very clear from the outset when I agreed to be a witness that I would do so in line with government policy at the time in question obviously being 2021 to 2023, so the previous Conservative government. I was surprised when I was asked to join the Cabinet Secretary's meeting with the DPP that was the decision. I think I only picked up the last bits of evidence that the DPP gave at that meeting. I said exactly what I would say in an open court. That obviously gave him pause because he asked for another meeting with Council on the 9th of September where I again repeated very much the same refrain that I have given to you today about what I would be able to say.
So Matthew, are you saying to us that you were prepared, if you had taken the witness stand in this case, to have said something more directly relevant to what CPS were looking for, i.e. China did pose a threat to the national security of the UK?
So what I said I would be able to say is that China poses a series of threats to UK's national security. These include espionage threats, cyber threats, threats to our democratic institutions, threats to our economic security. I believe what they were asking me to say was to use the generic term that China is a threat or China is an active threat, which is not in line with government policy at the time. However, the way I would have answered the question under cross-examination would have been to go through all of the areas where I've specified in my witness statements, and I would do again so verbally, the range of threats that we see from China.
But DPP didn't feel that they would ever get to that point in the trial, did they? Because they felt the defence lawyers would have struck out your witness statement as not disclosing an offence.
I don't know. I know what I was able to say, what I would have said in an open court. I know what I have said in my witness statement.
Very shame we never get to hear that. But Chris, I've got a quick question for you too. Because when you met DPP on the 3rd of September, he came, according to his evidence to this committee, to tell you that the case was being dropped. But that's actually not what happened, was it? After that meeting, you had another go, I understand it, to see if you could stand up a case that would allow this trial to proceed. Is that not correct? Did you ask the DPP to see if he could find a way of making this go to trial?
Not explicitly, no. So, but
hang
close.
On. Implicitly?
Yeah. Well, so the course of events was exactly as the DPP described. He had, I now understand, though I didn't know at the time, seen the Attorney General to inform the Attorney General of his decision. He then came to inform me of the decision and explain his reasonings. I asked that Mr. Collins join the meeting, and the DPP explained his reasoning to Mr. Collins. Mr. Collins raised a number of questions about the statements that the DPP had made, and the DPP agreed that there should be, I can't quite remember what exact words the DPP used in the hearing, but he covered this. He agreed to one more loop, which led to the meeting on the 9th of September.
Did you ask for that further?
No, I didn't. No, we didn't ask for the Mr. Collins, and he might describe what he said. Raised a series of questions, and the DPP volunteered to look into those questions, which is what led to the meeting on the 9th of September, and then his subsequent confirmation that he was going to fulfil his intention not to present evidence.
This was your last gasp attempt to try and keep this case going, was it?
As I've described, I was somewhat surprised on the 3rd of September to be asked to join the meeting where, and it was obvious when I joined that the decision had been made. I set out as plainly as I could in response to the DPP what I would say in an open court, which is to say that China poses a range of threats to our national security and highlight in detail the ways in which they do. He then, as the Cabinet Secretary has described, suggested that there was another loop just to make sure that there was no further scope to take this forward.
I want to bring in Andy Slaughter, and then we're going to have to move on.
It's just, thank you, Chair. It's just a codicil to Lord Hutton's question. Your surprise was because the range of threats that you very cogently explained, you thought was sufficient for the purposes, and had you given evidence that you would have come up to proof, but you wouldn't have gone beyond that. At the same time, the CPS is asking for more information, more statements. Did that not make you think that there was more that you needed to say? Not that you necessarily would have done, but you would have come to that conclusion, because it does rather look, from that point of view, more cock-up than conspiracy, if I can put it that way, but it also seems to be one of the great misunderstandings of national security.
So every time a request came in for more information, myself, the team working with operational partners did our best to service that request. I was advised throughout by external counsel, and I discussed several times with my legal team whether we felt we had given enough. It was his advice that he thought we had. You might want to ask him. He probably still thinks we have.
Yeah, if I can add to your question, I mean, obviously, so I am not an expert in this case in the way that Mr. Collins is. I wasn't involved up until the events we're discussing here. But on the 3rd of September, the new information I received from the DPP was the importance of the Rousseau case, as discussed with Ms. Thornbury. And I say I'm not a lawyer and I'm not an expert in the case, but I left that meeting with the clear impression that that was what had changed. It was the Rousseau case, and the DPP described the impact in exactly the way that he described it in this hearing, that was what had moved the bar in this case, and that was what had led the DPP to seek further evidence on top of that, which had led to the original charging decisions. I say, I can only speak for myself, but that was the new information. That was what I thought the new information that had been delivered to me that explained the change was. I don't know if that was the same for you, Matt.
Very briefly.
Yeah. Mr. Collins, you are an experienced and long-serving, dedicated public servant who has been at the heart of our nation's security for a good many years now. Is it your view, as a matter of fact, that China's espionage operations in this country threaten the integrity of our democratic institutions?
Yes.
Is that expression of fact something that ran through all three statements that you gave in this case?
Yes.
Then it is hardly a wonder that you are surprised that this prosecution was dropped. Thank you.
Mike Marsden. Mike?
Thank you, Chair. I'm muted. Am I muted?
No, we can hear you.
No, apologies. Thank you, Chair. So if I may to both of you, perhaps to Sir Chris first, just a couple of just clarifications of fact, please. So the current NSA is a SPAD. He's a special advisor, a political appointee. Does that in any way affect his, the nature of his engagement in handling the legal side of national security? I mean, does it compare differently to previous national security advisors? For instance, Sir Mark Sedwell, who sits on this committee, or Lord Sedwell now.
In some small regards, yes. So Mr. Powell fully complies with the Special Advisor Code. He does not play a role in line management. So unlike when Lord Sedwell was National Security Advisor, Matt Collins reports in line management terms direct to me, not to the National Security Advisor. And there are also limits on what executive decisions the National Security Advisor can take in line with the Special Advisor Code, and those specific decisions are either taken by me or by one of the Deputy National Security Advisors. There is no restriction, obviously, on the advice that the National Security Advisor can give to the government, which can obviously come from a Special Advisor or a civil servant. In this particular case, the relevance is because we were discussing matters that happened before Mr. Powell was National Security Advisor. He would have no role in the evidence, regardless of whether he was a Special Advisor or a minister or a civil servant, because he was not in government at the time that the offences occurred.
Thank you. And that's quite interesting there. So Mr. Collins reports to you as the Cabinet Secretary because he's unable to report to his Special Advisor, the National Security Advisor. But I understood from your previous comments, Sir Chris, that you came quite late to this issue. It sort of came across your desk perhaps in early September. Is that correct? Do you think you should have been across it earlier than that?
In detail, yes. So I knew the case was going on. I knew that Mr. Collins was the witness. I knew that Mr. Collins was providing witness statements, but of course I was not in government. Well, I was in government, but I was not in Cabinet Office or my current role between 21 and 2023. I was in the Department of Health.
How long after you were, sorry to interrupt, but how long after you were appointed did you actually hear the kind of details of what was happening in this case?
The case in detail, not until September. I knew the case existed. That is not a surprise. As I say, I was not in Cabinet Office or a national security role between 21 and 23, and I would have no reason to know the details. As Mr. Collins set out earlier in this hearing, he was under very strict instructions as to who he could share information with on a need-to-know basis, well, actually beyond the need-to-know basis, and I had no need to know.
Okay, thank you very much. And then just to both of you, just probably a very short answer can handle this. Perhaps Mr. Collins first. Just for clarity, did Jonathan Powell seek to provide any views or influencing decisions at any point in this case?
No. I informed Jonathan that the case existed. I informed him that I would be a witness in that case when he took up post. I didn't discuss any further details about the case with him after that.
Okay. And thank you, Mr. Collins. And Sir Chris, is that your understanding as well?
Sorry, yes. You will be unsurprised to hear, looked into this question and spoke to Mr. Collins and Mr. Powell, as well as reviewing the written evidence. I've seen absolutely no evidence at all that there was any influence on the case from Mr. Powell.
Okay, thank you. And then just no one really from number 10, anyone else had any influence. Mr. Collins was in his legal bubble, and we can just say that quite clearly, can we?
Yes.
Okay, thank you. And then final question. Sorry,
I really do need to move on.
Okay,
I'm sorry. Dame Karen.
Thank you very much. Mr. Collins, thank you for coming in front of us today. I'm sure you didn't expect that you'd be doing this when you were involved in this case. I just want to get to the nub of this point about the current threat at the time the offences were committed. So when you were putting together your original witness statements, would you have referred to your line manager at that time, the National Security Advisor?
So in putting together the original witness statements, I think, as I mentioned in a response to Baroness Tyler, the team that work for me within NSS work very closely with operational partners in pulling that witness statement together, consulted lawyers, external counsel, and then I consulted the National Security Advisor at the time, and also the Cabinet Office Permanent Secretary. The reason I didn't consult the Cabinet Secretary at the time is he was on a period of medical leave. I then cited the Prime Minister on the first witness statement.
So when the investigators came back to you and said they needed further evidence, did you at that point consult either your current line manager, or did you refer back to previous line managers? So did you talk to the previous National Security Advisor to get more information about what the threat had been at the time?
So after I submitted my first witness statement, I think in April 24, a charging decision was made. After that, my legal counsel advised me that I shouldn't share my witness statements, and so in providing responses to the various different requests for more information that came from our perspective from counter-terrorism police, but obviously forwarded on from the CPS. The only people that I consulted with were the small team who'd put together the statements for me and my legal advisors.
And you were asked by counter-terrorism police to reflect the current government's policy in your witness statement?
Yes.
So I see there's a potential issue here, because the National Security Act, I appreciate, deals with a lot of the problems that this case had. And if the NSA was in place, it was in force at the time, we wouldn't be in this situation. But clearly there have been offences committed, and there may be other offences that were committed during the time that before the time the NSA was in force. You've said that you, as a civil servant, will reflect current government policy. So are we in the situation now where if there was any case coming forward that had happened at a time under a previous government, that you would not be able to give the evidence that was needed to demonstrate what the threat was at the time, because you're under an obligation to give the evidence of the current government, or the position of the current government?
If I'm able to rewind a little bit, this is a very unique set of circumstances. Operational partners for a long time were frustrated that they weren't able to bring kind of exactly these types of offences to justice because of the difficulty of the Official Secrets Act from 1911. And if you read the provisions in the Act, you'll see that it is kind of inevitably written for a completely different time. They have taken other disruptive action, and so you will have seen the espionage alert that MI5 put out around the activities of Christina Lee. But they didn't feel that was sufficient for the types of threats and activities that they were seeing, and therefore I was asked to support the prosecutions both for the Rousseff case and in this case as well. I took that on. I understood that would be a challenge in both cases. Actually, I was prepared to give evidence in an open court under the Rousseff case as well. I was very thankful that I didn't need to, but I was fully prepared to do so in this case, noting from the outset that it was always going to be a challenge.
Yeah, sorry, I think if I've understood your question correctly, then the answer is no. So nothing in current government policy prevents us giving evidence about previous governments, the threats and
my point was that Mr. Collins had said that as a civil servant he was obliged to reflect the policy of the current government. I absolutely understand that is the role of officials.
Of the government at the time of the offences, not the current government.
But clearly there was there was a statement in the third witness statement that was taken from a answer to a question in the House of Commons from a current minister, not a previous minister. And I just wonder why the previous minister's statements were not reflected in the same way.
I was asked by counter-terrorism police to include language from the current government in my witness statement because I believe they were concerned about the defence trying to demonstrate that there was a difference in policy position, and so we were trying to basically negate that line of attack.
So that's where I get confused, because if that's the case, then it means you can never reflect the policy of the government at the time of the offences, because you are using as a matter for the defence the current government's policy, and that's where I get the contradiction comes.
So, as I understood it, my evidence, all of my evidence related to the activity at the time between 21 and 23 in delivering that, those witness statements. I said I would be in line with the policy of the government of the day. I was then asked for a specific addition, and it is those paragraphs that you're referring to. That was the response to that specific addition that I was asked to from CTP. And
you didn't think about taking some of the statements, answers to questions from the ministers who were in place at the time, for instance? So I mean, there's plenty on the record of government ministers at the time suggesting that China was a threat. There were many statements that had been made by government ministers. If you could use an answer from a current government minister, could you have not used one from a previous government minister?
Throughout all my witness statements, I drew from published government documents, namely the Integrated Review and the Integrated Review Refresh, to articulate what government policy was for the Conservative government at the time.
Thank you.
Gavin.
Thank you ever so much. So Chris, when were you first aware of the CPS's repeated requests for evidence?
Sorry, when was I
first aware that the CPS were making repeated requests for evidence?
Well, I knew that there was a ongoing process between Mr. Collins and the CPS. I did not know the detail of that until the 3rd of September.
But you knew before the 3rd of September, didn't you?
Well, I knew there was a process of
you knew
additional
early in
witness.
August, didn't you?
You
knew much earlier than the 3rd of September about the CPS requesting evidence of Mr. Collins. Is that correct?
Not what the nature of the request was, no.
As Cabinet Secretary, it's probably fair to say that you would be in receipt of legal advice on many issues, isn't it?
Yes.
Yeah, regularly, I imagine. And it's fair to say that really, I mean, when we listened to the evidence of the Director of Public Prosecutions, it was quite clear to him, and it was quite clear, and it was quite also clear to, Mr. Little, that actually where the evidence stood that the case was going to collapse. You'll probably have had a similar reading from... No, you didn't.
No.
You weren't that interested in this case. You were that detached.
No, it's a...
Were you so detached from the case on this significance that you couldn't be bothered to ask any questions?
If you'd like to let me answer the question, we maybe can make some progress.
If you would answer the question, we'd make more progress, wouldn't we?
Would you like me to? It's an independent decision of the DPP.
So you're Mr. Collins' line manager, and you're that sort of negligent as to really show no interest as to where the case is?
No, I follow the rule of law.
But you have you had no idea that the repeated request for evidence was because that the case might collapse.
Mr. Collins has set out that he was under a series of legal restrictions as to who he could share his evidence with, including up to contempt of court proceedings. He followed those correctly.
So this was like a real bolt out of the blue. You were that sort of far away from it all. That sort of come the 3rd of September.
No, we were following clear legal advice, which is what we do.
Mr. Collins, it's quite fascinating because you continue to use the line in line with government policy. It feels as if it's almost a defensive line. Of course, there is government policy, but also there's you'll be offering your judgment continuously to government, won't you? In your judgment, not in relation to policy, is China an active national security threat? Because a lot of your colleagues, if you take Sir Ken McCallum, seem to take the view it is a active national security threat. What's your judgment, your personal judgment, not what government policy is?
I'm a civil servant.
But you have a judgment.
I'm a civil servant.
And you're bound to give this committee your view, not actually, we're not asking for what government policy is. We can read numerous documents as to what government policy is. We're asking for your judgment, Mr. Collins. What's your judgment? Do you believe that China is an active national security threat as Deputy National Security Advisor?
So, as Deputy National Security Advisor, as a civil servant, I see a lot of information, a lot of very concerning information. I see the information that Ken McCallum does, and I see the range of threats that China poses to our national security.
So is Sir Ken McCallum wrong?
I don't think.
Sorry, Sir Chris. I wasn't asking you the question.
No, but this is a question of fact.
Sorry, can we?
A question of fact.
Can we? Excuse me. Can we just actually have some decorum in this? And can we just keep the questions really more about the communications between the CPS and the government? So, Chris, you can answer.
Yeah, I mean, just as a question of fact, I don't think Sir Ken McCallum has ever used those words. So if you have a reference where he did, I'd like to hear it.
So obviously when the National Security Advisor was in China, he met with his counterparts. There'll be notes taken of those meetings. Was the issue of this case raised in those meetings?
No.
No. Okay. Thank you.
Paul Robertson.
I should be extremely brief, not least because we're past our time. And this is specifically for the Cabinet Secretary, and I see you as representing the government on this occasion. Should somebody in the government have intervened when it became apparent that the CPS needed more evidence, and Mr. Collins's evidence wasn't sufficient for what wanted prosecution? And if I could add with that, if you had concerns about the way in which an espionage case was progressing, would you raise that with officials and ministers? And what role does the Office of the Attorney General play here? And we haven't heard about him. Are you satisfied with the Attorney General's work in superintending, which I believe is the expression of the CPS?
So the answer to your first question is no. The circumstances in which the government relates to the Crown Prosecution Service have been set out very clearly, I thought, by the Attorney General's evidence to this committee. I'm sure we will talk about it tomorrow, but it's, in my view, entirely inappropriate for government to intervene in criminal trials in the way that you describe.
Lord Sedgwick. I just wanted to come on to the point really about what lessons you think that we've learned from this case. Perhaps to start with you, Matthew Collins, what lessons have learned and what changes do you think you need to make going forwards?
The second question is easier than the first. The second question is obvious. The answer to the second question is obviously the National Security Act, which, if it had been in place, I think, as Dame Karen Bradley suggested, we wouldn't be having this conversation. In terms of the lessons, I think a more open discussion directly with CPS earlier would have been helpful. Personally, I was quite clear from the outset of what I would be able to do and would be able to say. I've been consistent, and my team will tell me annoyingly consistent throughout from autumn 23 until this day. But there was obviously a kind of I don't know, not miscommunication, but a place where what I was able to say wasn't at the level that the CPS required. And so if we would have been able to have more conversation earlier, I think that may have been the lesson learned.
Chris?
Yeah, I'd agree with all of that. In particular, around the 1911 Act, it's clearly deeply unsatisfactory that an Act written for a completely different age is not really appropriate for the 21st century. And that therefore the most important lesson was the passing of the new Act.
There's a risk that our judicial system could be seen by others, particularly China, in the light of what's happened, as being open to influence. So, Chris?
I haven't seen any evidence that our judicial system has in any way been influenced. I think... Sorry?
There's a prospect of it.
I would say no, for the reasons set out, that we have a very specific set of circumstances around how the wording of a very out-of-date Act of Parliament were used in this particular trial, a problem that Parliament has resolved by the passage of the new Act. So in terms of other governments, with which China or anyone else actions going forward, I would assume they would understand that Parliament has changed the law and that the bar for prosecution in these sorts of cases is now very different from that under the 1911 Act.
Remember, you want to come in briefly?
Thank you. Between December 21 and February 23, Mr. Collins, would you say that China posed a range of active threats to the UK?
Yes.
Yes. Anybody having problems with Rousseff and saying that it needed to be that China posed an active threat, we are talking about one angel on top of a pin as opposed to 14 angels on top of a pin.
Can I just put one thing to you finally, and that was a report in the Times, just going back to that meeting that took place on the 1st of September that we were discussing a little bit earlier, where it was alleged in the article that the group suggested that the Attorney General should raise their concerns with the CPS. Is that true, Sir Chris?
No, and I'm sure the Attorney General will confirm this tomorrow, and indeed I think it is in his written evidence. As a matter of routine, as I understand it, the Attorney General's office monitors with the CPS the course of important and controversial trials, but they have confirmed they raise no issues of public interest or anything else with the CPS, but I'm sure the Attorney General will confirm that when you speak to him tomorrow.
Okay. Can I thank you both for your time this afternoon? It's much appreciated. I appreciate it's run over as well. That concludes our second panel of this session and of the inquiry. Thank you again.